Yep, that's your art. But was it copyright infringement? I'm Andre Minkoff, the founder of Trademark Factory, and in this video, I'm gonna share my thoughts about yet another screw-up. This time around, it's Ai Weiwei fighting with Volkswagen over what he says is copyright infringement. Alright, let me start by reading from the article, and you can always find the link in the description below. Ai Weiwei sues Volkswagen for using refugee life jacket artwork in ad. Ai Weiwei recently filed a lawsuit against Volkswagen and its Danish counterpart Skandinavisk after he said his artwork appeared in an advert from the German automaker without permission. The legal battle surrounds his Soleil Levant 2017, a sprawling installation that sees the Kunsthal Charlottenburg's facade packed with approximately 3,500 life jackets that were all salvaged from refugees in the island of Lesbos in Greece. Okay. The artwork was on display at the Copenhagen Gallery from June to October of 2017. It was then featured as the backdrop for a Volkswagen Polo campaign in October the same year. Ai Weiwei encountered the ad back in March of 2017. What? So, there's something wrong there. They say the artwork was on display from June to October 2017. The art was featured as the backdrop in Volkswagen's campaign in October, and Ai Weiwei somehow encountered the ad back in March? How does that work? Okay, anyway, so he encountered his ad back in March of 2017, probably it's March of some other year, maybe 18 or 19, and claimed that his work was used without permission, and he was not credited as the artist. I am suing Volkswagen in Denmark for violating my intellectual property and moral rights, said the artist in an Instagram post. Now, there's a big difference between intellectual property, or copyright to be specific, and moral rights. Copyright focuses primarily on the rights to use, the commercial exploitation of the work, whereas moral rights refer to inalienable personal rights that stick with the author, and these are very strong in Europe, much stronger than they are in common law countries, especially US or Canada. So what he's saying is that he sued them for two reasons, and moral rights are all about indicating the author of the work when you use their work. It's also about integrity of the work. You can't use somebody else's work for certain purposes, so that's why he's claiming moral rights. Okay, I can understand that. So let's keep going. The infringing material was circulated to over 200,000 people, giving the false impression that I had authorized Volkswagen to use my artwork in its ad for the new Polo. On Tuesday, Weiwei posted a selfie on Instagram flipping off the Volkswagen logo. On the way to Copenhagen to attend the court hearing for our case against Volkswagen, read the caption. Alright, that's his selfie. Okay? The following Wednesday, the hearing took place at Glostrup District Court in Copenhagen. A representative for Volkswagen Denmark told CNN that the company would not comment on ongoing case. However, the spokesman said the company had admitted its mistake and had tried to reach a resolution with the artist for the past year, reports CNN. The artist claimed that he had unsuccessful attempts to resolve this matter with Volkswagen. Volkswagen and other multinational corporations have tremendous bargaining power in intellectual property protection, as well as environmental and human rights, he wrote. They're not above the law. What does environmental and human rights have anything to do with this? Beats me. I guess it's just one of those anti-capitalist, anti-success arguments that, oh, they're making a lot of money, they must be bad people. Okay, well, let's keep reading. All right, let's actually also read what Weiwei said in his Instagram post. So this is the image, this is the ad. So we see the installation. All right. We see the car. We see something else. Well, probably a posing bicyclist, or I doubt that there was a stranger because then they have to get released. But okay, let's keep reading. So he says, I'm suing Volkswagen in Denmark for violating my intellectual property and moral rights. My artwork, Soleil Levant, if I remember anything from my French lessons, it's the rising sun, which I created for World Refugee Day, was installed at Copenhagen, Kunsthal, Charlottenborg from June 20th to October 1st, 2017. The work comprises 3,500 life jackets used by refugees who fled to Lesbos, Greece, escaping persecution and conflict. In October of 2017, Volkswagen Denmark used an unauthorized photo of Soleil Levant in an ad for its Volkswagen Polo campaign. I was not credited as the artist, and my artwork image was uncredited and cropped without permission. The infringing material was circulated to over 200,000 people, giving the false impression that I had authorized Volkswagen to use my artwork in its ad for the new Polo. I was astonished by Volkswagen's brazen violations of my intellectual property and moral rights. Since November 2017, I have been trying to resolve this matter with Volkswagen. In more than 1 year of fruitless negotiation, they only engaged in arrogant gestures to trivialize their guilt and dismiss the matter. Intellectual property protection lies at the heart of a society that values human invention and makes our useful accumulation of knowledge possible. Respect of intellectual property law is one of cornerstone of a functional international legal system. As one of the largest European companies, Volkswagen should understand these same laws. Volkswagen and other multinational corporations have tremendous bargaining power in intellectual property protection as well as environmental and human rights. They're not above the law. Human rights, like intellectual property, is a popular concept, but one that is difficult to enforce. We should remember that Germany took in 1 million refugees in 2015, a powerful humanitarian act in a divided world. As one of Germany's internationally most visible companies, Volkswagen's disregard for fair play and humanitarian issues is truly disturbing. Okay, I have mixed feelings about it. Really, I do. Because some of the arguments that I make about intellectual property, and especially moral rights, make sense. But the second he starts going off about how many refugees Germany accepted and environmental and human rights, all of that has nothing to do with copyright infringement, is nothing to do with moral rights, is nothing to do with what Volkswagen actually did. And when I hear such arguments, I'm wondering, why do you have to go there if you are so sure that you can win on the merits of the actual copyright infringement case? So that's a big concern. Now, beyond that, there's a couple more things I wanted to point out. Now, this is actually more complicated than it seems because it's not an image that Volkswagen used without permission. They used installation that was shown in public. So it was in a public place that anyone can go and take photos from, and actually it's the photographer who would own the photograph. Now the question is, when the photograph is taken, it obviously includes an underlying work as that installation, but so does the building. There's an architect who designed the building. There's somebody who designed a lot of things that we see in photographs. So are they all copyright infringement? Is pretty much every photograph a copyright infringement because it might cover something, right? So for example, if you take a photograph of somebody wearing a pretty dress, did you just infringe on the copyright of the designer who designed the dress, right? So the way this is usually resolved is that the courts look at whether the use was deliberate or incidental. Was the use of the particular artwork specifically included in the ad to sell more polos? Or was it just something that looked nice and certainly was not made the focus of the picture? That's really where the biggest discussion will happen in court. But from the moral rights perspective, this is also interesting because, so what moral rights do, they give you the right to the name, right to be recognized as the author of the work. They give you the right to prevent any modification of your work without your permission. And so he's claiming, well, it was cropped. Well, what was cropped, right? It wasn't that they cropped the actual installation. Volkswagen didn't come with a chainsaw and cut the installation so that it fit their ad better, right? They took a photograph and they cropped it to their liking. There's nothing, if anything was cropped, it was the photograph. So it's not about Weiwei's rights, it's about the photographer's rights. And I'm sure they got a release from the photographer of that photograph and the designer who put the ad together. So I don't say it's one way or the other, but my question really is whether it is infringement or not. Does it really matter how much money Volkswagen made selling polos using this ad? Should it influence whether the court recognizes if there is an infringement or not? I don't know, right? Apparently they tried to come up to some sort of a settlement, and Ai Weiwei wants to make this into some sort of exemplary hanging of Volkswagen because they don't do enough on the environmental, human rights, and refugee fronts? Is that what is that the reason why? So you caught them and so I think you should now pay reparations for, what is that the whole point of this? Because if it is, then it's a really backwards way of doing things. All it does, so you say they're trivializing the infringement. Really, if that's your way of getting there, if that's your way of getting them to pay more, is to say that they're not respecting environmental issues and this or this or this or that, anything that has nothing to do with intellectual property, then who's trivializing the intellectual property infringement? You are. So I think that really what needs to happen here, and what probably will happen here, is that Volkswagen really wants to make this go away. They're going to find a number that will be acceptable to the artist, and we will never hear about this case ever again. But this could be an interesting one because here's commercial use, used for an ad, but was it incidental or was it specific enough that was focusing on Weiwei's art? We don't know. I would say it's about 50-50. And frankly, the more Ai goes to discuss things that have nothing to do with copyright, the more he weakens his own case. So we'll see how this develops, and if there is a development, I'll be sure to let you know. So if you found this video useful, well, subscribe now, get notified whenever the next one goes live. And until then, I'll see you in the next video.